your meeting today.
Good morning. I'd like to call this meeting of the General Law Committee to order. So March 21st, General Law Committee. We are actually going to go into call the meeting to order, and then we're going to go into recess until 12:30, at which time we will reconvene and we will see you all then. So thank you. Oh, it's on. Let's see who can get up those stairs faster.
No, slower.
Uh,
Slower.
I say like I assume.
Am I on join you? Yeah.
Yeah. Oh, yeah. Yeah, a little evidence here. So we're the kitchen sink door of the general assembly. I don't know if you give us the bad rolls in the roller. You've got one already. We know that. Ah, damn it. I had one funny thing to say and Roland took it. I think that's still back. He was funny.
Where's the channel?
All different topics. So you get to learn so much. Really all from town. Something like that.
Representative Pulis, Representative Grader,
Good afternoon. The chairs have asked me to reconvene the meeting and go immediately back into recess. There's still some caucuses and meetings going on before we start our business today. So we will go into recess until the call of the chair. It might be a good time for everybody to go grab some lunch because then we'll be here a while once we reconvene. So we'll be in recess to the call of the chair. Thank you, everyone.
All right. Good afternoon. We are going to reconvene the meeting, the March 21st meeting of the General Law Committee to JF Bills. We're going to open with remarks by the chairs, and I will pass it along to my co-chair, Representative Lamar, to lead us off.
Thank you all very much for joining us here today. This will be the first of two concluding JF meetings. We hadn't originally scheduled a Monday meeting, but we will be taking up additional bills on Monday that we will not get to this afternoon. I first want to say just a quick comment. We hosted a public hearing here on Wednesday. We had so many members of the public who were able to come out and join us and testify in a series of bills on our agenda. We invited a number of people to give us some expertise advice that they had that the committee we thought would benefit from hearing. One of the individuals testified in a way that his testimony could have been misconstrued or misheard, but it led to a subsequent action by Department of Consumer Protection where he felt, and this committee feels inadvertently or purposefully, his business was put in jeopardy. It is our goal as a committee to be a place where constituents feel welcome coming here, opening up themselves to their expertise, to their knowledge, to sharing with us their challenges that they face, whether it's as an individual in their home or a business that they're running. Now, you and I may or may not disagree with the individual who came here today and what he wanted to share with the committee. We may or may not agree with the business or the business model itself as a whole. But it is my hope that this space, this place, is seen as a space where people can come and share those differing opinions and those differing ideas without fear. I have an expectation that that I can offer that space here in this committee room. I failed to offer that space in this committee room. While I don't necessarily think the fault was mine, this was the space I invited people to. And so I hold it as a failing. I've had incredible conversations with the leadership of the Department of Consumer Protection. It has been made clear to me that this action was unacceptable and in no way inherent within the department itself. I have complete faith and commitment from Commissioner Caffarelli, who I've grown to really enjoy and think he's doing a superb job. And I have complete confidence that this will not happen again and the situation will be rectified internally. And with that, I know there's a series of bills on today's agenda where I asked to enhance the powers of the Department of Consumer Protection. We have agency bills on behalf of the Department of Consumer Protection. I still maintain that those are good ideas and good policies, and they bring forth a better Connecticut because of them. But we won't be asking you to vote on a lot of them today. And with that, Mr. Chair, turn it over to you.
Thank you. And I would just like to follow up by saying that trust often takes years to earn. I think Representative Lamar and I have both worked for years being open and listening to all sides to build that trust. But unfortunately, it can be gone in moments. And so just to echo, what Representative Lamar had said, we invite everyone here because it makes for better legislation. In Connecticut, we believe in free speech. We have unlimited debate in our legislature that many states do not have unlimited debate in their legislature. We allow any citizen to come up and testify before us, and we encourage them to do so, whereas in some states you have to be invited to have the ability to come up and testify. So we do take that very seriously. We respect and listen to differing viewpoints. Not everyone will agree with the decisions we make, but it is important that we hear both sides and people feel free to come and share that publicly, because the alternative is we're only meeting with people behind closed doors, and open government is better government. And so I also want to echo Representative Lamar's statement in that I have the utmost faith in Commissioner Caffarelli. I spoke with him this morning, and I know he's someone, I know the department has spent a while building that relationship with the businesses, and we can't go back. We can only go forward. And in the coming days and weeks, we will work together to rebuild that trust. So with that, I'll turn it over if the rankings have anything to say.
Thank you. Thank you, Mr. Chairman. I'll be brief. I just wanted to express on behalf of our members on the committee, that we share the outrage of the leadership of the committee that a citizen who wanted to address or redress their government on a concern would be then targeted for action. We think it's outrageous. We don't think it's right. But we also want to say that we share the confidence in the Commissioner of the Department of Consumer Protection to rectify the situation, to look into it, and to make sure that it never happens again. So with that, I thought the chairman and the both chairmen did a great job expressing our feelings, but I wanted to let you know that we are all of like mind. Thank you.
Senator Ciccarello.
Thank you. And a lot of what I was going to say was said, and I do agree that this should be a place where individuals could come and be able to contribute. It's a very important process. As I became aware of this, I did have a conversation with Commissioner Caffarelli, and he was equally as concerned and frustrated. And he said he's going to look into this, and I have full confidence that he will, and the appropriate actions will be taken. So we make sure individuals and the public will be comfortable and have no fear of coming here and speaking before us. So I just wanted to echo that I do have full confidence in the commissioner and his team to address this appropriately, and we will move forward so we could continue to do the business that's very important with the participation of the general public. Thank you.
Thank you very much. With that, we'll move on to item number 3 on the agenda, bills for final action. Representative Lamar, would you like to, or
I move item number 1, HB 511, and not concerning mobile manufactured homes, which I have to the floor.
so there's a motion to JF HB 511, 5111 to the floor. Is there a second? Seconded by Senator Kissel. Okay, there's been a motion. It's been seconded. Is there any discussion? Representative Lamar.
Thank you. This is the first of 2 mobile home manufactured home bills that before us. The first one defines ancillary fees, requires park owners to prepare and publish comprehensive itemized list of those fees that are payable to residents, requires that information concerning those fees be included in a disclosure statement, require that DCP establish a resident complaint process for folks who have issue with that, and it requires park owners to provide at least 90 days advance notice of proposed rent increases. And then again, it prohibits certain rental agreements from having duplicative ancillary fees. I would just call attention about why we're regulating mobile manufactured homes in this manner, different than a traditional home in some meaningful way. There was great public testimony provided on this bill and the subsequent bill. I would call attention to testimony from Raphael Podolsky, who helped us clarify what's going on here. That first, mobile homes are a bit of a misnomer, right? They are not, in a meaningful sense, to paraphrase Mr. Podolsky, mobile. They're manufactured housing. They're brought to a park on a flatbed truck. They're placed on the foundation, and there they stay, anchored to the ground. It is really expensive to move these mobile homes. And what makes that even more complicated is almost every community in the state of Connecticut has made it illegal to build a mobile home park. So in fact, once you get access and control over a currently situated mobile home park, you have almost unfettered ability to charge people and raise rents, raise increases, charge ancillary fees, and that person is trapped. It's not a mobile asset. I know that there are some concerns with this bill and a subsequent bill that Representative Martinez will articulate in a few minutes. I get that there's concern. What are we doing? How do we get to the bottom of this? I think this bill is one of a few approaches that we have to provide protections to folks who are in a uniquely vulnerable spot in relationship to a home that they own being on land that they do not control. So through you, Madam Speaker, I urge adoption or passage. Sorry.
Thank you, Representative Lamar. Representative Ackert.
Thank you, Mr. Chairman. And just a question regarding ancillary fees, because not being a park, I agree with the additional increases. And if you had to move one of these, because as somebody that works at a park, when it has to go out there, I know they're not mobile in any really mean. But in the ancillary fees, the one section that I'm looking at, it talks about a 90-day notice before a fee can be increased. What what would a typical ancillary fee? Because I'm thinking if it's something that has to do with a urgent action that needs to take place. So I'm not sure exactly what is included in ancillary fees, and that if you had to take action on something and then you can't charge an increase in it for 90 days. That was my only question on this bill.
Thank you. Begin to define ancillary. Thank you. We begin to define what ancillary fees are internal to the bill, but they're conventional fees that may appear in addition to your traditional rental agreement for the actual rent of the land or the pad that you're on. Pet fees, trash fees, other associated things that might be add-ons to the stated disclosed rental agreement. So increases to those, if you were currently paying $4 a month because you have a cat and suddenly it's $12 a month for its cat, you got to give someone 90 days before you do that. It's those types of increases that are ancillary to the traditional rental agreement that exists for the space.
Thank you, Mr. Chairman. And I appreciate that answer because I didn't want it to be something that was a volatile price range and all of a sudden it's up and down and you got 90 days. So that was all I wanted. Something like a stationary fee. That's typically something, I got a shed on there. So if I got a shed, that fee to have a shed on the property is such and such. So I appreciate that answer. Thank you.
Are there any further questions? Senator Ciccarella, followed by Representative Vitigliano.
Thank you. As we're just saying, how important the public testimony part of our job is, clearly there's an issue, and there's going to need to be work done to make sure individuals are not taken advantage of, and even some of the smaller owners of these parks. We're kind of surprised to see some of the increases of rents and fees, which are much higher than theirs. But we want to make sure when addressing this and helping the individuals that do need it, we're not hurting small business owners or business owners. And I do believe, as the chair said, that they're going to continue to work on this and be able to find a solution. And I do think there needs to be something done. And I think this is the step in that right direction, but I do believe we're going to need to do a little bit of work on this. And I want to make sure this gets out so we can do that. So I will be supporting the bill. Thank you.
Thank you. Are there any further comments? Representative Osborne.
Thank you, Mr. Chair. I was heartened to see this bill come before us. There are obviously problems going on in the mobile homes and the mobile home parks, and this bill is a really good start to address some of the unique things about mobile home park issues that are separate and different from traditional real estate issues. So I am very happy to support this bill today. I know that everything that comes out of a committee is always a work in progress. And I look forward to, offering any additional thoughts that may be necessary into working on this issue so we can really support and protect people from being victimized in the way that they have. And thank you, Mr. Chair, through you.
Thank you. Representative Vitigliano.
Mr. Chairman, I'd like to offer that we start a consent calendar.
Just stand at ease for one moment.
Turn left. Don't get in an accident walking out the door. So I could say the words without objection. Okay. So what do we, am I good?
You're good. Start one.
Yeah, we have to start the consent. Representative Hallie Brennan. And then
Thank you. Thank you, Mr. Chair. And I want to thank the committee for working with me on this bill. I just wanted to provide some context. This is a direct response to what happened to the Shady Acres community in my district in Danbury, where a legal loophole allowed the park sale to move forward without giving residents a fair shot at purchasing their community. So this bill is, aimed to help fix that. It's about fairness, transparency, and, protecting these residents from being pushed out of their community. So I really do appreciate the committee giving us an opportunity to get this out and to keep working on it and really, show this community that we're standing by them. So thank you.
thank you very much. So this has been offered for the consent calendar. So is there any objection to adding this item to the consent calendar? Hearing none, this item has been moved to the consent calendar. Okay. Item number 2. House Bill 5428. I would entertain a motion to JF that bill to the floor. Moved by Representative Martinez, seconded by Representative Lamar. Is there any discussion? Representative Martinez.
Thank you, Mr. Chair. This issue, I found out about this issue well over a year ago as a visiting nurse. I was going to see my patients, and I had several that were living in manufactured home communities, and I was hearing about their issues and concerns. And some of their issues were pretty significant, and they are in a different situation where they're a little bit more it's a little bit more problematic for them to get out of these situations, such as increases in rents. Rents were going up pretty drastically, and with these people, they cannot just get up and move like it was said earlier. It costs thousands and thousands of dollars to relocate. So when a park owner goes to renew a lease and the person doesn't agree to the rent increase, they're either stuck paying it or they're stuck footing that bill. They also have these ancillary fees that were mentioned a little bit previously that are for things like washers and dryers, pets. And these rent fees and these ancillary fees, these people own their homes. So they're only renting the patch of land. So they could have a cat and have to pay $25 a month, and those fees could be increased with the new lease, and they own their home. So it's not causing any problems to the home. And the park owners, although they have definitely their fair share of maintenance with public areas, they don't have usage or wear and tear, or they're not fixing things when things go wrong in the homes. So another issue I was hearing about is when they did try to voice their concerns or there was complaints, I heard several issues with things like trees falling down and tree removal. They would voice these concerns and they were unable to check on their complaints. They were unable to get information because it was not part of the Freedom of Information Act. Several residents had issues with fire hydrants in, especially in East Hartford, where we saw what happened there, not once but twice, where a manufactured home park had a fire in 2019, and the firefighters arrived and the water pressure was not where it should have been in the fire hydrants, and the fire truck had to use its water pressure. And then that happened again in 2024, damaging 6 homes. So I tried my best to get these concerns into this bill, and I want to say I really appreciate the support from the chairs on this committee. So what this bill will do is it would put a rent cap to 1% over CPI. It would put a cap on ancillary fees. It would give FOI, it would strengthen FOI and make it available so that people could look up and get their complaint information. It also looks at raising the relocation fees. So currently, if a park owner was to change the usage of a park, they would pay the relocation fees, but that has not been updated in years and years, and this puts it to what a relocation fee would actually cost. And this would also require that park owners would have to report regularly to DCP, giving the water pressure and ensuring that the fire hydrants are safe and that they're keeping the residents safe. Through you, Mr. Chair.
Thank you. Senator Kissel.
Thank you very much, Chairman Maroney. I very much appreciate the concerns raised by the good representative who advocated on behalf of this bill. And while I was happy to support the previous mobile manufactured home bill, I'm going to have to vote no on this one to flag it. Happy to work with the proponents on this bill as it moves forward, should it pass the committee this afternoon. But the sanctity of contract is important. People's property rights are important. I believe there's constitutional guarantees. Sometimes with our proposed legislation, as laudable as the ends may be, you're certainly taking away someone's rights and quite often not compensating them for that. And so, yes, it's difficult out there. And in fact, one day I got out of a Judiciary Committee meeting a little early, and I watched this marathon Housing Committee hearing where my friend and colleague, Senator Sampson, was asking a lot of questions. But these are intractable issues in Connecticut in many respects, whether it's a mobile home park or if it's just condominiums or any other kind of housing. And I have personal experience from my ex-wife. I mean, where she lived is a beautiful place, and then got sold to a new, and the first thing the new owner did was raise the rents. And now she's finding it very difficult to be able to stay there. And that's not a mobile home park. It's just a colonial home that actually has people upstairs and my ex-wife downstairs. So this is happening everywhere in every part of our state. But for the reasons I articulated, I'm not going to be able to support it this afternoon. Thank you, Mr. Chair.
Why don't you go
Rep-
first? Go ahead.
Representative Lamar and then Senator Ciccarello.
Thank you. And I want to commend Representative Martinez for her steadfast work on behalf of this bill for the last few months. It was the first conversation I think I had with you back when you were first elected and you came before me. I think you've done an incredible amount of work working internally with LCO, OLR, with mobile home community members from across the state. You've done really exemplary work to get us to this point, and you are to be commended for that. There's incredible testimony attached to this bill, both in favor and in opposition. I encourage people to understand sort of the very unique, specific issues that mobile home park residents are dealing with and why this is a little bit different than a traditional person who's being pushed out due to rent costs on a colonial home. This is their asset, and they can't move it anywhere else. And just to get up and leave would mean to leave everything behind. I do think it's worth considering some type of regulatory control. I'm not afraid to say this. I'm a liberal who's opposed to rent controls, right? I generally don't like them as a policy tool. I don't think they necessarily work, but in this very specific instance, with this very specific population at this type of development, I think they might have applicability. Richard Friedman from Garden Homes submitted incredible testimony in which he highlighted that there's only been one new mobile home park built in the last 15 years in the entire state, just to highlight how difficult it is for folks to just get up and move one day. One new in the last 15 years. They did it. And they had to use 830G to get it built, right? It's that difficult to get it done. But he also raised some points about rent caps, and maybe this rent cap structure at CPI +1 doesn't allow for some special exemptions or exceptions that may temporarily force you to go above that 1%. Suddenly there's a huge problem on site and you need to repave the entirety of the thing. There's a water main collapse and you got to get in there, and the only way that you can finance a loan is to have a temporary assessment. So that might be something I work with you to try to figure out what some of those exclusions could potentially be. But I think you're on the right track, and I appreciate and commend the work that you've done.
Thank you, Senator Ciccarello.
Thank you. And as I said on the previous bill, I understand that there's room to fix problems that we're seeing. And when doing that, we do not want to go too far and create other problems. In this piece of legislation, I see just that. I think we're going to swing the pendulum a little bit too far in the opposite direction. When we talk about the rent caps using CPI, sometimes that goes down. It fluctuates too much. I think we could do something to address that concern, but the way it's being done here, it's just a huge problem for me. Also, the FOI process, I think that also is going too far. These are private company, and they're going to be opened up to FOI for an investigation if DCP is looking into something small, and they'll have to turn over all their information to anyone. So it could be a competitor, it could be anyone. So I do believe that there's concerns there. And the ancillary fees, people that are, you know, taking advantage of people because they know they don't have other options, that is a concern. But we heard from the smaller owners when things come up, septic systems or bigger costs, it's part of doing business. And when we put such a large piece of legislation, in my opinion, weighted a little bit too far in the direction of the tenants, it could hurt the business owners and really could have an effect where people won't build them or won't want to own them any longer. And, you know, even the appraisal process, I know there's not mobile home parks in every town. And if there's not a comparable comp within that town, they could go pretty much anywhere. We've seen there's some that are on the water, there are some that are in the woods. Those things make a big difference when it comes to the property value. So for that reason, unfortunately, I cannot support the piece of legislation before me. I urge my colleagues to do the same. Thank you.
Thank you. Is there any further discussion? Representative Yacarino.
Real quick, Mr. Chair, and I appreciate the good representatives that intent here. I would offer maybe a compromise. If the 1%, if you had a tax increase in a municipality, it's got to be in line with that. You can't, 1% is really not enough. Not saying you should do it every year, but you have to have some sort of alignment, because unfortunately municipalities are raising taxes, so you'd want to keep it in line. So I think you'll get more support that way. And like the good chair said, Lamar, they're not being built, unfortunately or fortunately, but they're just not being built. But we want to have a fair balance. And I know you're trying, and I did support the first bill. I will be a no here, but I think if you could try to have that balance, I think it could work much more amenable to everybody, I believe. So that's all I have to say. Thank you. Thank you, Mr. Chair.
Great. Thank you. Are there any further comments? Okay, hearing none. Madam Chair, will you please call the roll?
Okay, a motion has been made and duly seconded to JF to the floor, HB 5428, an act concerning mobile manufactured home parks. Senator Maroney,
Senator Maroney votes yes.
Representative Lamar,
Representative Lamar votes yes.
Senator from Farah, Representative Turco,
Yes.
Senator Ciccarello,
No.
Representative Rutigliano, Representative Ackert, Representative Ali Brennan,
Representative Ali Brennan votes yes.
Representative Aniskovic, Representative Candelaria, Senator Gadkar Wilcox, Representative Gibson, Representative Jensen.
Representative Gibson votes yes.
Oh, okay. Thank you, Representative Gibson. Representative Jensen, Senator Kissel, Senator Lopes,
Senator Lopes votes yes.
Representative Luxembourg, Representative Martinez,
Representative Martinez votes yes.
Representative Osborne,
At this time, Representative Osborne votes no.
Senator Austin, Representative Paolillo,
Representative Paolillo votes yes.
Representative Santos,
Representative Santos votes yes.
and Representative Yacarino.
Representative Yacarino votes no at this time.
Thank you, Mr. Chair.
Great. Thank you very much. Moving on to the next item, item number 3. I'd entertain a motion to JF to the floor, House Bill 6052.
So moved, Mr. Chair.
Moved by Representative Lamar. Is there a second? Seconded by Representative Martinez. Is there any discussion on this bill? Representative Ackert.
Thank you. Thank you, Mr. Chair. And I get it. We don't always enjoy, a door knocker at the house or a sales call, but again, they are trying to make a living. I know that when we go out and do our campaigning, and the first thing you see on a front of someone's driveway is no trespassing, no solicitation. It's a very, very simple thing to have in your yard or by your door. But when I saw the fees and the potential fines for this, and kind of the very confusing language, not I should say confusing language, but the amount of time you can be on a property and things like that. That was one of the things that flagged. Also, maybe a question to you, Mr. Chair, is there resources that would be provided to the Department of Consumer Protection for the additional staff that would be potentially required for this through you, Mr. Speaker? Yeah, we'll throw you, Mr. Speaker, over there, Mr. Chairman.
Representative Lamar will respond.
Thank you, Mr. Chair. Thank you for your question. No, at this point in time, additional resources are not contemplated to go to the Department of Consumer Protection. It is something that I've talked to the chief proponent of, and that they do recognize that if we were to put this much onus on the department, we would probably need to find a way to pay for it.
I totally agree. If we're going to do that, and that's, I always do. As you know, we've been here together the same amount of time, and within available appropriations, which never seem to appear, those available appropriations. So I don't want to. The other one that I was Section 2 dealt with individuals that may have a history of a felony or something along that line that specifically cannot, for given reasons, that cannot engage in this type of work. And it's quite a large. And so the question I had in Section 2, it looks like it's not just like the solar. It looks like any door solicitation, these individuals that may have a history being in one of our, anywheres, haven't been arrested for certain violations, would almost be unemployable in this type of in any of those careers. Do you read that the same way, Mr. Chairman?
Thank you. Through you, Mr. Chair. Thank you. I read it the same way, that applicability would be broadly based, not just to the solar industry. I would highlight that list is not as broad as you think it is. It's a very narrow group of people who've convicted of violent crimes would be prohibited from going door to door. And I would highlight, based upon the testimony we received from both Department of Consumer Protection and during their agency briefing, and from Representative Lenahan, who was the chief proponent of the bill, just in 2023, we fielded over 15,000 scam contractor complaints, and there were we've only now recovered about 700,000 in stolen contractor funds. The door-to-door sales marketplaces where a lot of this is taking place, a lot of high pressure tactics, people identifying folks who may be elderly, may be vulnerable, coming up to their door using high pressure tactics. People kind of agree to things to get them off the front door. So some of those fraud scams have also turned quite violent, where there have been dangerous break-ins, where one person will talk to someone at the front door whilst the person will go around to the back door and the person won't know. So we think that people who feel particularly vulnerable, who may not have an in-depth security system, should be able to have a no-knock list that will give them a level of protection and surety in their community. That all being said, the proponent of this bill recognizes that there's going to be some work done, and that there are concerns not just in this committee but in other committees about who is impacted by some of these exclusion lists.
I appreciate that, Mr. Chairman. I think I just recycled encyclopedias that my parents bought in the 60s when I moved, and I'm sure that they were probably purchased by somebody that was doing their due diligence to sell some encyclopedias, and probably a vacuum cleaner. So, but on that, I'll be a no at this time. If it changes and goes to the floor, I'll relook at the legislation and that language. So thank you, Mr. Chairman.
Thank you very much. Senator Kissel.
I know we don't have that much time this afternoon. I'd like to be associated with the remarks of Representative Ackert. Thank you.
Great. Thank you very much, Senator Kissel. And I would just say that it's March 21st. We adjourn on June 4th. I would consider everything, no matter how well-baked it may seem today, is a work in progress. And you have my commitment and Representative Lamar's commitment. We're both very open to work with people as things move on from the committee until they reach the floor of the House or the Senate. Is there any further discussion? Okay, hearing none.
I was just going to comment that I'm voting yes for that exact reason. I wanted to let everybody know that I think that this is a serious problem, and all this is an imperfect bill that needs some work. I'm willing to vote yes to keep it working. So, thank you.
Thank you. And by the nod, I assume Senator Chicarella would like to associate himself with your remarks. So we'll +1 on that. So again, if there's any further discussion, hearing none, Madam Clerk, will you please call the roll?
Okay, I would just give members online a second to turn their cameras on so we can record their votes. Okay, motion has been made to JF to the floor, HB 6052, an act concerning the Home Solicitation Sales Act and residential solar photovoltaic systems. Senator Maroney,
Senator Maroney votes yes.
Representative Lamar, Senator Fonfara, Representative Turco,
Yes.
Senator Chicarella, Representative Vertigliano, Representative Ackert, Representative Ali Brennan,
Representative Ali Brennan votes yes.
Representative Yanukovych, Representative Candelaria, Senator Gadkar Wilcox, Representative Gibson.
Representative Gibson votes yes.
Thank you. Representative Jensen, Senator Kissel, Senator Lopes,
Senator Lopes votes yes.
Representative Luxembourg, Representative Martinez,
Yes.
Representative Osborne,
Yes.
Senator Austin, Representative Paolillo,
Representative Paolillo votes yes.
Representative Santos,
Representative Santos votes yes.
Representative Yacarino.
Representative Yacarino votes yes.
Thank you, Mr. Chair.
All right, thank you. Next item, item number 4 and 5 are going to be held. Item number, is 6 being held? 6 we're doing. Item number 6, I would entertain a motion to JF to the floor, House Bill 6930.
So moved, Mr. Chair.
Moved by Representative Lamar and seconded by Representative Ackert. Is there any discussion?
Consent calendar. Mr. Chairman, I'd like to motion this to the consent calendar.
Okay, is there any objection to moving item number 6, House Bill 6930 to the consent calendar? Hearing none, item number 6, HB 6930 is moved to the consent calendar. We are holding item number 7. Item number 8, I would entertain a motion to JF to the floor, House Bill 7179.
So moved, Mr. Chair.
Moved by Representative Lamar and seconded by Representative Osborne. Is there any discussion on this one? Okay.
Mr. Chairman, I'd like to offer this item up for the consent calendar.
A motion has been made to add item number 8, House Bill 7179, to the consent calendar. Is there any objection? Hearing none, the item will be moved to the consent calendar. We are holding item number 9, House Bill 7181. And so the next item is item number 10, House Bill 7182. I would entertain a motion to JFS to the floor, House Bill 7182 with LCO 6651. Moved by Senator Kissel. Seconded by Representative Turco. Is there any discussion? Representative Ackert.
Thank you, Mr. Chairman. So I know that, and I can't think of Neil from UConn had brought up some concerns with that, with this affecting UConn. Has any of that? It looks like it's S language. Did you have any conversations with UConn on this issue? And
Representative Lamar.
Thank you. I don't think UConn's testimony was related to this specific provisions in this bill. I think it was another ticketing bill that was before this committee. I may have missed UConn, so I have not spoken to them about this bill. I will revisit those conversations with them if I see them. But to date, I have not had any conversations with them about the parameters of this bill specifically.
Okay, because thank you, Mr. Chairman. I appreciate that. I had concerns from UConn and DC and Department of Consumer Protection when I read through the testimony. If there's any other dialogue, I'll relook at my notes. But at this time, I'm a no on this legislation.
Great. Thank you. We understand. Representative Vitigliano?
Did you want to respond? I think that one of the problems DCP had with the bill is that referred to the person who owned the tickets. It had certain language where it said a reseller or something. I think that's corrected in the JFS. What wasn't corrected in the JFS, Mr. Chairman, and we may want to discuss whether or not we want to amend it here right now verbally, was on lines 88 and 94. It refers to a price cap on ticket resales. And I was wondering if we wanted to remove that as we bring the bill forward. Move the bill forward. I would like to offer that as an amendment, sir. Good enough? All right.
Mr. Chair, I would accept that as a friendly amendment to remove the price caps that are associated with the bill upon LCO's referral.
Okay, a motion has been made, and so I'm assuming that Representative Lamar can consider that as a second. Of
Yes.
the motion to amend the bill. The chamber will stand at ease while we wait for the LCO to. The room will stand at ease.
Mr. Chairman, I'd like to withdraw my amendment and then make a new one.
And Representative Lamar, would you like to withdraw your second?
Mr.
Is
Chairman,
there any further discussion?
Mr. Chairman, I'd like to offer an amendment that we remove subsection F and that LCO be allowed to make conforming changes throughout the bill.
Great. So there is a motion to remove subsection F and to allow LCO to make technical and conforming changes to the bill.
And I second that motion.
Motion has been made by Representative Vitigliano and seconded by Representative Lamar. Is there any discussion on the motion? Hearing none, I think voice vote is okay. Okay, all those in favor of the amendment, please signify by saying aye.
Aye.
All those opposed? Okay, so the motion carries, so the bill has been amended. Is there any further discussion on the bill as amended? Okay, hearing none.
No, yep.
Madam Clerk, will you please call the roll?
Mr. Chairman, I move this to be put on the consent calendar as amended.
Okay. This item has been offered for the consent calendar. Is there any objection to adding HB 7179 as amended to the consent calendar? Oh, as amended to the consent calendar. Hearing no objection, we'll move that item to the consent calendar. We're cooking with grease. Okay. Yeah. And now that right. Okay, next item is Senate Bill 2. There's JFS language. So I'd entertain a motion to JFS Senate Bill 2 LCO 6685 to the floor.
So move.
Moved by Representative Vitigliano. Second? Is there a second?
Second.
Seconded by Representative Turco. Just quickly, I'll go through a quick summary of the bill. SB 2 comes in, it's a large bill, but it really breaks down to three parts. Protect, promote, and empower. So protect our protections for Connecticut residents from AI. So sections 1 through 10 and section 28 do some regulations on developers and people who use AI to avoid algorithmic discrimination. There are transparency requirements to let people know when AI is making an important decision about them. There is a right to appeal if a decision was made on you about by using wrong data, as well as to correct that data. We also put in criminalize deepfake non-consensual intimate images, so revenge porn. And then we further require the AG to do outreach to make people aware of their new responsibilities in regards to AI. The promote piece we develop, we're looking to work with CASE to develop a tool to help people comply with the bill and know if they need to comply with the bill, to create a regulatory sandbox, to expand the Connecticut Online AI Academy. So in addition to the free training that we're already giving, to create a Connecticut Teen AI Academy and a Connecticut Small Business AI Academy, creating courses for small businesses on how to use AI to be more efficient. We're asking DOL and the Office of Early Childhood to notify people they work with about the free AI training, creating a Connecticut Tech Advisory Board to formalize those conversations going forward between government, industry, and academia, asking DECD to work with Connecticut Innovations to create a tech transfer program. So what's that? A tech transfer, Yale has that, and UConn, but not all of the other colleges. So it's to help professors commercialize their inventions. The smaller colleges don't necessarily have the ability to do that like the larger colleges do. Expanding existing programs like the Tech Fund to include AI training and creating a state tech plan. The empower is how do we empower the state government to use AI to more efficiently serve our constituents, working with the state employees to solicit ideas for pilot programs, developing training for state employees on how to responsibly use AI, and then also creating a working group. With that, are there any questions? Senator Kissel.
Thank you very much, Mr. Chairman. Less of a question than why I'll be voting no at this time. Certainly, I applaud you as one of the leading proponents of these kinds of bills in the nation. Clearly, I think Connecticut planted a flag when it came to data privacy, and I think you're noted throughout the country. And in actually many respects, Connecticut is the gold standard by which other states had patterned some of their legislation going forward. In this area, though, both last year and now this year, we see a little bit different regarding this. And the area that I'm most concerned with is the first section, as you outlined it. I was here when Commissioner O'Keefe of the Department of Economic and Community Development testified on this proposal from India, expressing the concerns of the Lamont administration. And on this particular issue, I agree with the Lamont administration and Commissioner O'Keefe that this particular area, artificial intelligence and its expansion and technological innovations, may turn out to be the goose that lays a giant golden egg. It's an area that's moving at light speed, and we are geographically in a wonderful position between New York and Boston. We have very educated folks here in our state. We have a great incubator system at the University of Connecticut, as you indicated with the third part of the bill, trying to expand that a little bit to smaller areas and companies as well. So there's a lot of good in this bill, and I'm certainly not voting no because I think it's all bad at all. But I think that when we try to get into that area of concern, major concern that you have, like how did the artificial intelligence algorithms come up with a particular response, a particular answer, and making sure that it's not being done illegally and with bias, and trying to drill down into that. If I'm an innovator, if I have a lot of investment capital, I'm not going to come to Connecticut if I have to reveal my secrets. I understand you want to know what they're doing to make sure that they're not ending up violating some of our laws, being biased, making decisions that violate our human rights and opportunities. I get that. But I don't want to strangle the baby in its cradle. And I think that this area is such a burgeoning area. And I've seen federal initiatives where they're harnessing hundreds of billions of dollars from throughout the world to come to the United States and invest. And this could be, as the commissioner indicated, the next giant revolution. We had the industrial revolution, then we have a medical revolution, technological revolution. This is just another huge area that could just explode. And I always analogized it to the locomotive, right? Locomotive was a scary thing when it hit the scene in American history. I mean, there were communities that wanted nothing to do with the iron horse. And you know what? It was coming no matter what. And if you were one of those communities that originally was on the pathway of a railroad and you just said, hey, we don't want it, guess what? They did not flourish. They languished. And it probably wasn't too many decades down the road where they were wishing they had not driven away the rail service. Is this a little different? Yes, it's more than just transportation of ideas. That would be more like the internet. This has a creative area where the logarithms are harnessed to try to rapidly come up with results that are then utilized by businesses. But I think if you study the net result of whatever the logarithms come up with, and let's just say, I think right now, as we speak, businesses are utilizing this. If they have job applications in the thousands, they're not going to pay someone to weed through 1,000 resumes and applications for the job. So they'll probably just crank in certain information into the front end, use their AI programs and algorithms, and spit out different candidates that meet their qualifications. I understand the goal that we'd like to know what those algorithms are based upon to try to make sure they're not using unlawful criteria. But I think what we have to do, not to kill the baby in this cradle, is we have to be mindful that a lot of these are proprietary information, cutting edge technology, things that folks are not going to want to reveal here in Connecticut. And we're going to have to discern through the net results, the end results, was there illegal activity or not illegal activity? And that's somewhat what we do right now anyhow. We get complaints from the public saying, I feel I was discriminated against. And then we will do some research based upon that. And if we have some initial criteria that would allow us to make an initial decision that I think that on its face, there's a viable complaint here, then we can do a further investigation. I'd much rather have a system that utilize that than one that is going to frighten away all the investment capital that is just going to be out there in the next few years. This is going to move real fast. And there's going to be winners and losers, not just in the United States, but internationally. And first of all, I hope the United States of America is a huge winner when it comes to this. And as it plays out, this is just like, you know, being master of the airway, of the air when it comes to the military, right? If you can go farther and faster than your other nations, you're going to be in a more secure position. I want Connecticut to be a secure financial situation, a secure economic situation. I want us to be able to catch the ball when these folks throw the ball. And right now, I'm just very concerned that the path that we're pursuing is going to be at odds. I hope that you can work it out with the administration. But at this time, I'm going to flag it. I have great concerns regarding going down the artificial intelligence path because I think that the net result could be we could be one of those towns that miss out on the railroad and it's going to pass us by. And for those reasons, Mr. Chairman, I'll be voting no. Thank you.
All right, thank you very much. I'd just like to point out railroads are on track so people know exactly where they're going, and we do put limitations on them, speed limits and other things. And, you know, as I looked in my refrigerator this morning, I looked and saw that I can look on items in there and I could see what was in it, right? And just because you know what goes into the cake doesn't mean you know how to make the cake. There are trade secret protections and other things, but I also looked at the eggs and the meat, and they were inspected by the USDA, so I know they're safe. And this bill simply looks to test something before you use it to make an important decision about someone's life to see, is it fair and is it accurate? I've talked with a lot of innovators and companies who do want guardrails. In fact, Boston Consulting Group did a survey in 2024 of businesses, and the true revolution from AI is not necessarily going to come as much from the inventors as from businesses adopting it and using it. But 62% of businesses are holding off on fully embracing AI until there are clear-cut government regulations. So if we're able to work with them, we can actually grow this faster. But thank you for your viewpoint. Are there further, is there further discussion? Senator Ciccarello.
Thank you, Senator. I do know that you've been working on this tirelessly, touring the country, and you're well researched. I commend all of the work that you're putting in, as well as all of the conversations you're having with all of the stakeholders. And I know there are concerns. Other states may not be doing this yet. We're going to do it. What is that going to do to our business, climate here in Connecticut? And those are legitimate concerns that I share with Senator Kissel. I understand the intent, and I think there are great things in this bill. AI is amazing. Trying to learn how to use it. Maybe I'll take one of those classes that you guys are going to be putting out. But we do have some concerns, and I still know it's a work in progress. I look forward to continue to pay attention, see what those changes are. But there are some concerns when it comes to smaller businesses. I do know that you made some changes as far as a developer or a sub-developer, if that's the right term, where you're going to not hold a small business liable if the retailer of that software complied. If you could just briefly explain that.
Correct. Yeah. Thank you, Senator Ciccarelli. Yeah, there's what we call an off-the-shelf AI exemption. So if you're using a program and the developer has said that they're taking on the risk, and there are companies that have already said they're indemnifying people for using their models. IBM has said that, some of the others. But if you are just using a custom program to screen your resumes, then you wouldn't be liable as a business, and you would be exempt from the majority of the requirements on the deployers. So,
excellent. Thank you for answering that question. And in this, the language change with the legislation before us defines the sub-developers. Is that relevant to what you just said?
That so the developer sub-developer is actually a little different, and so what that is a lot of people. I'll use myself for example. So from outside of here, I'm building an AI chatbot, and I'm training it on my own material, but I'm using ChatGPT to query that and answer questions. And so in that case, you would be a sub-developer using something from a larger developer. A lot of people aren't necessarily going to build their own new big models because of the cost. They're either going to be using open source, or they're going to be using what's called an API, application programming interface, to access one of the larger models to then so if you were going to access a larger model to make an important decision, again, the important part of this bill is what is high-risk AI. It's something that makes an important decision about your life, and we've been narrowing that down on what it is so we can take away some of the unintended consequences. But if you're using something to make an important decision about someone's life, you should test it to make sure it's fair and accurate.
Thank you for answering that. So just a quick question off that. So if a small company is using AI, specifically ChatGPT, and they're just conducting daily business, they're not making decisions, hiring, et cetera. Does that small company have to notify their clients that they're using that?
No, the notification would be if you're using it to make an important decision, right? So this doesn't impact if you're building a chatbot on your website to just answer questions, but if you're building a chatbot to decide if someone's going to get a loan or not, then you would have to test it. But if you're just answering questions about loans, or just answering questions about whatever your service you provide is, or if you're using ChatGPT to summarize documents to help you with your marketing or other things, that's not drawn in this bill.
Excellent. Thank you for answering those questions. I know those are some of the concerns last year as we talked about this bill, and people were just, trying to make sure that they're not going to be doing something wrong. Everybody's trying to follow the law, do the right thing, and they don't want to get wrapped up in this. So thank you for answering that question. And I know we are going to continue to work on this. I look forward to talking to you more about it. But for now, I'm going to be flagging this with a no vote, and I look forward to continuing to work with you.
Great. Thanks. Is there any further discussion? Okay. Hearing none. Madam Clerk, will you please call the roll?
Okay, members online, I'll just remind you that you need to turn your cameras on so we can record your vote. A motion has been made to JFS to the floor, SB2, an act concerning artificial intelligence, LCO number 6685. Senator Maroney,
Yes.
Representative Lamar, Senator from Farah, Representative Turco,
Yes.
Senator Ciccarella, Representative Vertigliano, Representative Ackert, Representative Ali Brennan,
Representative Ali Brennan votes yes.
Representative Aniskovich, Representative Candelaria, Senator Gedkar Wilcox, Representative Gibson, Representative Jensen.
Representative Gibson votes yes. Sorry.
Oh, sorry. Thank you, Representative Gibson.
You're
Representative
welcome.
Senator Kissel. Senator Lopes,
Senator Lopes votes yes.
Representative Luxembourg, Representative Martinez,
Yes.
Representative Osborne,
Yes.
Senator Austin,
Senator Austin votes in the affirmative.
Representative Paolillo,
Representative Paolillo votes yes.
Representative Santos,
Yes.
Representative Yakarino.
Representative Yakarino votes no.
Thank you, Mr. Chair.
Great. Thank you very much. Just a reminder, well, not a reminder because I didn't say it. Votes will be held open to the latter of 5 p.m. or the end of this end of this meeting. So I'm hoping it's 5 p.m. So next item on the agenda. I would entertain a motion to JFS to the floor, Senate Bill number 3 with LCO 6447.
So moved.
Moved by Representative Turco. Is there a second? Seconded by Representative Osborne. Okay, discussion. So just to summarize this bill, there are six sections. Section 1 is language that is very familiar to the committee, as I think it's been in 2 other bills, the junk fees provision, so-called junk fees provision. Section 2 is the connected devices, so preventing using information that a Siri or a Google Home Alexa would listen to for advertising. Section 3 is right to repair appliances, so electronic appliances, small and big. Section 4 is a requirement for the municipalities in Connecticut to move to the .gov domain. There is actually federal money from CISA so there is assistance for people to move over. And in the long run, in addition to being more secure, there are additional securities. There's more trustworthy. It ends up being cheaper for the municipalities. Section 5, again, this is similar language, the price gouging language. It does create a committee that would meet. So it's if the Attorney General, it gives the opportunity for just, in addition to a state of emergency, the Attorney General to declare an economic disruption, but the committee could meet to veto that. And then Section 6 is notwithstanding language. With that, is there any discussion on the bill?
Thank you, Mr. Chair. What I would have said on Section 2 applies here as well. The tremendous amount of work you personally have put into a number of these issues in relationship to Senate priority bills over the last couple of years is remarkable. There's stuff in here that appeals to almost every resident in the state of Connecticut who feels aggrieved in some meaningful way. I know there's going to be some concerns about this bill. I know that there's work that you've committed to continue to do with a number of folks, but I'm proud to stand next to you as you've worked on this bill over the last couple of years and like, again, emerge as a true consumer advocate on so many issues. And thank you for your work.
Thank you. Representative Fratigliano.
Thank you, Mr. Chairman. Mr. Chairman, I haven't read through the language. Is there anything in here addressing some of the concerns by our first responders over the drone language through you?
Through you, the drone language has been removed from this, and so there is no language in here regarding the drones.
So, I mean, thank you. I guess we don't even have to do that in here, right? Different set of rules. So we have concerns over the bill. We have the same concerns that we had last week when we passed the Attorney General's bill. It just seems to be a bit of a power grab and an overreach on the economic emergency through the Attorney General's office. It is unchecked power. And even though it does say there's a group that could recommend that he stop, he has the ability to renew the emergency on his own unilaterally. There really doesn't seem to be a way. It asks him to consult certain heads of departments, but then he doesn't have to take the advice of those departments. So that, plus the fact that we believe that even though we are against foreign-made drones, there was a simple fix in there that possibly could have helped some of our first responding and our agencies that they were looking for, so they could continue to use drones that they've already purchased. With that, some of us will be voting no. So I just want to get that on the record. Thank you, sir.
Thank you, Representative Acker.
Thank you, Mr. Chairman. I echo the concerns of the good ranking member. Yeah, I look at duplicative powers here that we already assigned to the governor. If the governor's not able to do that, for whatever reason, the lieutenant governor has those powers, and now if absent of the governor for whatever reason. But in this case here, adding having the attorney general have the same powers as the governor, let's leave it in individuals' hands at this point. So at this point, I'll be a no. And look forward to further dialogue if there is on this. I don't think there would be. I think the attorney general is pretty happy with what is in here. So, but I thank you for the time and thank you for your work, Mr. Chairman.
Great. Thank you very much. Is there any further discussion? Senator Kissel.
Thank you, Chairman Maroney. I just have some questions because our good ranking member, Rep. Rutigliano, asked about drones, but I recall on the floor of the Senate, I thought we just voted on something regarding drones where there was an ability to write for an exception to like the 2030s. Can you just refresh my memory as to, because I thought we already passed something regarding drones.
Yeah, we already, and that's why it was removed from here was the ESERT, right? And the chief, the fire chief or the chief municipal officer has the ability to override, and I believe it was through 2036. It's either 2030 or 2036.
Yeah,
I'll double check on that.
Yeah, and I appreciate that because my recollection was like it was like the mid 2030s, and so it was like really very generous ability to extend the reach. So is this proposal before us right now a sort of an agglomeration of a variety of different proposals? And if so, like what bills were cobbled together?
Yeah, this bill came to us from the work of Senator Duff, and it's a number of different consumer issues that he's been interested in, like the right to repair being one. The connected devices is something that he had come across, an article of, like, I guess, recordings happening and different things with the connected devices. So this came from Senator Duff and his staff on a variety of consumer protection issues.
And I remember when our late good friend was concerned about repairing certain items, Representative Orange. And what is the right to repair in this proposal actually? What's its ambit?
Yeah, thank you. That's a good question. And so it requires manufacturers to make available to anyone the parts for repair that they would make to an authorized dealer, and to make the instructions available to people who want to repair their own either appliances or electronic devices. So it doesn't apply to farm equipment or to wheelchairs or other things. This is a narrowly tailored to electronic devices.
So back when the late Linda Orange, Representative Orange, had a similar proposal, I remember a lot of testimony from John Deere dealerships. So would the exemption of agricultural equipment apply to those dealerships that testified in opposition to a similar proposal years ago?
Yes, the exemption, and let me see, I think I have it circled. Hold on one second. I'll give you the line numbers. We just stand at ease for one moment. Electronic does not include any alarms. Any components maintain, manufacture, repair any motor vehicle, video game. Yeah, so it does not include any, so lines 182 to 186 of what it is, electronic or appliance product. And there it says does not include any alarm system, motor vehicle, or any component used to maintain, manufacture, or repair any motor vehicle or video game console. But I believe, if you give me 1 second, I think later on there's a further clarification where they specifically exempt the agricultural. Line, okay, allow me to skip some of the bill. So, right, down on line 354, down on, but on 359, that's where it lists some of the items that aren't counted. And so farm or utility tractor, farm implement, farm machinery, forestry equipment, fuel cell.
Thank you very much. And actually, the first ones you were pointing out, the video games, now that's jogged a memory axiom as well, because I remember that they actually came here in force. It was pretty interesting, that hearing, as I recall, about how video games, they didn't want anybody breaking them apart and figuring out how they were all put together. I still have concerns about that aspect of this bill, though. Requiring a bunch of folks out there that are manufacturing stuff and that maybe have specific dealerships that they feel entrusted to. I'm not sure, like, if we require someone who's making something to then give the parts and instructions to John Q. Public, and something blows up and their house burns down, like, is that manufacturer now on the hook for some kind of liability? Because my understanding is, with some of the complex items that we have out there, that if you have like a dealership, you will either have something online, like a video teaching course, or you'll even invite people to go someplace for a day or two and study how to work on the equipment to actually repair it and diagnose it appropriately. So I think it's a laudable goal, and there's like a very small group of people out there that want this right to repair. But I got to be honest, they don't seem to have stretched into my district, so I'm not getting a lot of emails or letters regarding it. I probably will after this afternoon, but I have concerns regarding that, and the chain of custody of items and exposure to potential liability. And again, if it isn't broke, don't fix it. And I just don't want to have Connecticut, as the federal government, whether you like it or not, is weeding through and cutting back on a lot of unnecessarily rules and regulations to try to make America more competitive internationally. I don't want Connecticut to be some backwater, and I'm not saying that's what's going to happen, but where we are the land of steady habits, and I don't want us to be over encumbered with rules and regulations that are not necessary. And so, I appreciate our good majority leader, Senator Duff, has a huge interest in these initiatives, and I appreciate that, but I haven't disentangled the wheat from the chaff yet. And so for that reason, Chairman Maroney, I'm just going to have to be a no to flag it at this time. Thank you, sir.
Great. Thank you, Senator Kissel. Your concern there is addressed in lines 308 to 316, where it says that you're not liable for something done by the owner. And I'm normally not the type of person to do that, but once I broke my iPhone and I did try to replace the screen, and it did not go well. So I ended up getting a new phone. Yeah, I did. Like, I should never try to fix an iPhone again. So is there any further discussion? Okay, hearing none. Madam Clerk, will you please call the roll?
Okay, a motion has been made to JFS to the floor, LCO 6447, SB3, and Act concerning consumer protection and safety. Senator Maroney,
Yes.
Representative Lamar, Senator Fanfara, Representative Turco,
Yes.
Senator Ciccarella, Representative Vertigliano, Representative Ackert, Representative Ali Brennan,
Rep. Ali Brennan votes yes.
Representative Yanukovych, Representative Candelaria, Senator Gadkar Wilcox, Representative Gibson, Representative Jensen, Senator Kissel, Senator Lopes,
Senator Lopes votes yes.
Representative Luxembourg, Representative Martinez, Representative Osborne,
Yes.
Senator Austin, Representative Paolillo,
Representative Paolillo votes yes.
Representative Santos, Representative Yacarino,
Representative Yakarino votes no.
Okay,
This is
Representative-
Representative Gibson.
you did make it online. Yes,
Yeah.
we vote.
Representative Gibson votes yes. Thank you.
Thank you. Okay, thank you, Mr. Chair.
Great, thank you. And again, votes will be held open to the latter of 5 p.m. or when this meeting ends. Next item on the agenda, item number 13, Senate Bill number 514. I would entertain a motion to JFS to the floor with LCO 6715.
So moved.
Moved by Representative Lamar, seconded by Representative Osborne. Thank you. Discussion. So just to quickly summarize, this asks OCC, the Office of Consumer Counsel, to create a net equality program where they set a price cap of $40, but each year they can be adjusted by inflation. There are some minimum speeds set, 100 megabytes per second down, 20 megabytes per second up. Again, it says OCC can't increase the cost and change the speeds. And then it says that state agencies cannot do business with providers unless they have an affordable internet program. With that, is there any discussion?
In this piece of legislation, does it have any safeguards to make sure that this bill, if passed, will not increase the cost to the average user that would not be able to get the affordable plan through you?
Yeah, through you, not through you, not to you. I guess we can just talk. Thank you very much. Let's talk here.
Through you, to
I can't say it never would, but what I can tell you is that right now, almost all of the major providers have affordable plans that are significantly less than $40. I know that Comcast is $10 a month, their affordable internet program. And I think by allowing the increase by inflation and OCC to increase it each year, I don't foresee that happening. I think it's something that they're already doing, and we do ask in the bill that they advertise and market it. And again, many of them are doing a great job of that, of marketing. But we do know, just as we discussed AI, that connection to high-speed internet is critical, right? And we know from the net equity plan in the state of Connecticut, over a quarter of Connecticut residents aren't connected currently to high-speed internet at their homes. Now, for some, that's by choice, right? They may be accessing it on their phone or mobilely, but we want to make sure, in many ways, just helping to market these plans to make sure as many people as possible are connected to high-speed internet at home. And again, looking at a lot of the training we're going to require in the future is online, right? Our Connecticut Online AI Academy. And there are things that you can do from a desktop or a laptop that you really can't do from your phone. So
Thank you. And I'll cut the formalities to through you because I'm just talking to you, I guess. So that's it. So, with your response, a couple of things that you said that kind of stand out to me. People or companies are already doing this. It seems to be working. And it's something that sticks with me. If it's not broke, don't fix it. And I think putting in this bill could have those unintended consequences. There's other bills that come out of this building that, again, when it's trying to help, it creates some unintended consequences or pushes maybe companies or people to do things that maybe they wouldn't have done, right? We see some stuff coming out of housing, makes a person that owns a multifamily think, oh, should I raise the rent now just in case this happens? And who does that hurt? It hurts the people that are renting the unit at a reasonable price. The whole, gas powered leaf blower. I use an electric leaf blower, but I might go out and buy one now just because I might not be able to get one, right? So, sometimes I think there's unintended consequences. And looking at this legislation, and for the sake of time, I won't go through all of my other questions, but I have concerns. And again, for the sake of time, I'm not going to go over all of them, but I am going to vote no on this legislation and encourage my colleagues to do the same. Thank you.
thank you very much. Senator Kissel.
I apologize at the outset to my good ranking member because he's urging me to vote no. But at this time, I'm going to vote yes. And I reserve the right that maybe vote no if it hits the Senate floor. And I've been apprised of issues that I'm not aware of now. But I agree with you, Mr. Chair, that I just think in this day and age, It is absolutely just like the oxygen we breathe, or a roof over our head, or food to sustain us. You need to have access to the internet, and you need to have it pretty close to home. I am aware that some people out in the four corners of the state, if they don't have access to the internet, they might be able to go to the local public library or something like that. But just when we were debating artificial intelligence moving at the speed of light, right? Well, the internet was not really all over the place when I started in this building 33 years ago. In fact, I was one of the co-chairs of this committee when we had barcodes piloted for the reading of prices on items that you could check out with, because at that time, every item had to have a price sticker on it. Yes, I was actually able to see around the corner of the future, and I helped engineer that pilot program, and it worked out real great when we said, and if you have the wrong price, you might be able to get it for free. It's like, that roast beef or something like that. I just can't imagine being stuck somewhere without access to the internet and trying to function in this world. And when we had the pandemic, and it's not that long ago, when kids were, if there was one young person in my son's high school in his class that had positive reading, they all had to work from home. That was hugely disruptive, but at least he was able to work from home via the internet. I can't imagine what would you do if those young people were not even able to access the information. And we just take it for granted. Sometimes I see these crazy public service announcements where they say, and if you have a problem with some power outage, just access the internet for your area of relief. And it's like, don't you get it that if they don't have power, they may not have the internet? And how are they going to find out where, a safety shelter is going to be? So we just almost just take it for granted for those of us that have it. So yeah, I agree with Senator Ciccarella that there's probably some areas that have to be addressed. And I would never want to support something that inadvertently caused my cable bill to go up, or my neighbor's cable bill to go up, or any of my constituents' cable bills to go up. But I'm hoping that's not the case. And so for that reason, with a little bit of trepidation, but hope, I'm going to support the bill to get out of the committee this afternoon. Thank you, Chairman Maroney.
Thank you very much. Representative Acker.
Thank you, Mr. Chair. And I'm just looking at some testimony regarding the federal implications regarding the conflicts with a section of the Communications Act of 1934 as it was amended. That provision states that no state or local government shall have any authority to regulate the entry of the rates charged by any commercial mobile service or any private mobile service. Has this been addressed in the S language at all?
I don't believe so, but it is modeled after a program that is in effect in New York State. And so I believe that it would have been challenged in court there. I'm not sure if there's pending litigation there, but I know it was based off of a bill that had passed in New York State.
Thank you, Mr. Chairman.
Thank you. Representative Iaccarino.
Thank you, Mr. Chair. I have a quick question. So the rates, how would they be set? Would they be set from, there's got to be a mechanism to set the rates for affordability. And I don't see that anywhere in the language.
Just stand at ease for one moment while I pull up the bill.
I could have missed something. I'm just.
Yeah, I'll point you.
It's a laudable goal. I'm just trying to figure out how are we going to dictate to the telecommunication companies or set the rates?
And so, okay. Okay, thank you. So I guess we'll come back.
Come back to me.
And
I want to support it, but I'd like to see some sort of.
So the initial,
mechanism.
it's initially set at $40 a month. It can't be more than $40 a month.
I don't, so it's, I must have.
And let's see.
I went through pretty.
They didn't use the numbers. That's why sometimes
Okay.
I just look in for numbers. It's spelled out on line 110. This section shall not exceed $40, and they have it written out instead of using the numbers. So the end of line 110, and then next it goes to not later than and annually after Office of Consumer Counsel shall adjust the maximum monthly cost. So again, 40 is the maximum that a qualified broadband internet access service provider may charge during the 1st of July in the year, in accordance with any change in the consumer price index for all urban consumers. So
I
it starts
appreciate
at
that.
40 and it gets increased every year.
But we're dictating to them the rate. Obviously, they're not coming up with that $40.
No, right. That was in there. The majority of them are already below that. I know or some are below that now. So I know Net Essentials, I believe, is $10 a month, and I'm not sure what the other programs are.
All right, I appreciate it. The only, my concern is if we dictate to the telecommunication companies that they'll raise rates to people that could afford it. And it's always a give and take, a yin and yang. But I appreciate your effort, and I'm going to consider this while you guys vote, while we vote. Thank you.
Just quick question, Mr. Chairman. How would the utility know if the resident would qualify for the program?
In the beginning of the bill, we list certain programs that, so if you're receiving SNAP, if you're receiving free lunch, there are certain ways that you would qualify.
Would the customer have to proactively tell the wireless provider or the internet provider that they were on a public assistance in order to get it? Because, I mean, just based on privacy rules, they wouldn't know without them telling.
Okay, so yeah, lines 33 through 51 define what a qualified public assistance program means. And then, give me 1 second. Yeah, it doesn't say, so they would have to ask for that, I would assume, because it just says to allow any resident who, during any month in which the resident qualifies as an eligible household to immediately convert to affordable broadband. And then to establish and maintain a telephone number, which members of eligible households may contact trained personnel.
Did this cover wired broadband services into your house, or is it also wireless?
It excludes wireless, so it is just the wired.
Okay. All right. Thank you.
Great. And thank you. And again, I appreciate the connection, the questions. Oftentimes we have different viewpoints, and we do spend a lot of time in here trying to anticipate those unintended consequences. So thank you for bringing those up. In some ways, I almost look at it as a marketing program. So when you created the free community college in Tennessee, it became the best FAFSA completion program ever because you required them to do the FAFSA to get there, and people are now aware that there are those opportunities. So we're making people aware of the opportunities. But I do understand we are setting a maximum on that, and there are differing viewpoints on what that can do. So with that, Madam Clerk, would you please call the roll?
Okay, I will give members online a second to turn on their cameras so that we can record their vote. A motion has been made to JFS to the floor, SB 514, LCO 6715, an act establishing a net equality program. Senator Maroney,
Yes.
Representative Lamar, Senator Fanfara, Representative Turco,
Yes.
Senator Ciccarella, Representative Ritigliano, Representative Ackert, Representative Ali Brennan,
Representative Ali Brennan votes no.
Representative Yanukovych, Representative Candelaria, Senator Gadkar Wilcox, Representative Gibson, Representative Jensen,
Jensen is no.
Senator Kissel, Senator Lopes,
Senator Lopes votes yes.
Representative Luxembourg, Representative Martinez, Representative Osborne,
Representative Osborne votes yes.
Senator Austin, Representative Paolillo,
Representative Paolillo votes yes.
Representative Santos, Representative Yacarino,
Representative Yacarino votes no for now.
And Senator Kissel, I just wanted to confirm your vote there, just make sure I was correct. Okay, thank you. All right, thank you, Mr. Chair.
All
This is
right.
Rep. Gibson.
Representative Gibson, how do you
Mr.
vote?
Chair, I apologize, Mr. Chair. I couldn't hit the button quick enough. Representative Gibson votes yes.
Okay, thank you.
Okay, so again, votes will be held open. Next, we are going to skip and come back to number 14, Senate Bill 797. We are going to hold Senate Bills 1235 and 1237. So the next item we'll be voting on is item number 17, Senate Bill 1249, an act addressing innovations in artificial intelligence. I would entertain a motion to JF that to the floor.
So moved.
Moved by Representative Lamar, seconded by Representative Ritigliano. This bill is from the governor's office. There are 4 sections. Section 1, it makes state data available. So it asks Chief Data Officer to examine and look at state data and develop policies and procedures to make that available for training AI systems. Section 2 develops a regulatory SDCD to develop a regulatory sandbox. Section 3 amends CUPPA to say that AI is not a defense against discrimination. And Section 4 creates an artificial intelligence and quantum technology investment fund that CT Innovations may fund from their existing appropriations. Senator Kissel.
Thank you much. Thank you very much, Mr. Chairman. What is a regulatory sandbox, just for my edification?
Yeah. Thank you for the question. And so regulatory sandbox is creating a safe environment for people and a pathway to compliance for businesses. So if you're a developer, so sometimes you could combine it with a test bed where you create a safe space for people to test their algorithm to assume that it's fair and accurate and that you don't have any outside data. So you may create data sets for people to use to test it. Or Utah created the first regulatory sandbox last year. And so they actually, I haven't read through it, but they contracted with the first company to be part of the regulatory sandbox, which was using AI to do mental health counseling, I believe was the item. But then it exempts you from some of the regulations and gives you time to come into full compliance. But basically, they want you to work in a safe space.
All right, I'm always a little leery of the safe space concept, but because I listened very intently to Commissioner O'Keefe, and I believe that at least in this one, and as I had indicated earlier, on balance, I'm going to err in this artificial intelligence battleground on the side of Governor Lamont and his administration. I'll be supporting this bill at this time to move it out of the committee. Thank you, Mr. Chair.
Great. Thank you. Is there any further discussion? Okay, hearing none. Madam Clerk, will you please call the roll?
All right, a motion has been made to JF to the floor, SB 1249, an act addressing innovations in artificial intelligence. Senator Maroney.
Senator Maroney votes yes.
Representative Lamar. Senator Fanfara. Representative Turco.
Yes.
Senator Ciccarella. Representative Ritigliano. Representative Ackert. Representative Ali Brennan. Representative Aniskovic. Representative Candelaria. Senator Gadkar Wilcox.
Senator Gadkar Wilcox votes yes.
Representative Gibson. Representative Jensen.
Jensen's no.
I'm sorry. Representative Gibson, how do you vote?
Representative Gibson votes yes.
Thank you. And Representative Jensen.
Jensen is no.
Thank you. Senator Kissel. Senator Lopes.
Senator Lopes votes yes.
Representative Luxembourg. Representative Martinez. Representative Osborne.
Yes.
Senator Austin. Representative Paolillo.
Representative Paolillo votes yes.
Representative Santos. Representative Yacarino.
Representative Yacarino votes yes.
Okay, thank you, Mr. Chair.
Great. Thank you. Next item on the agenda is Senate Bill 1295, an act concerning social media platforms, online services, products, and features. It's our committee children's privacy bill. I would entertain a motion to JFS to the floor, LCO 6091. Moved by Senator Kissel. Is there a second? Is there a second?
Seconded.
It's seconded by Representative, moved and seconded. So this bill just looks to make some changes to our children's privacy bill. We were actually, even though we weren't the first in the country to pass a children's privacy, we were the first one to go in effect because the other ones have been sued, and we've addressed their ahead of time. We looked at and anticipated some of the constitutional challenges. Section 1 requires social media platforms to create online safety pages with mental health and cyberbullying resources, as well as a policy for the reporting of bullying behavior online. Section 2 amends the definition of heightened risk of harm to minors to include specific mental and physical health harms. Section 3 changes the knowledge standard to how we know if someone is a kid to actual knowledge and knowledge fairly implied based upon objective circumstances. Requires both data protection assessments and algorithmic impact assessments, prohibits direct messaging from unconnected adults to children. So the change here is we used to require tools. Now by default, we're requiring they be turned on, so that if you're not connected, you shouldn't be able to message, direct message a child you're not connected with. Impact assessments, if they create a heightened risk of harm to minors, they have to have a plan in place to mitigate those harms. And the same goes in Section 5 with the, that was the data privacy impact assessments with the regular impact assessments in Section 5. Yes. Senator Kissel.
Thank you very much. And Mr. Chair, I just think you're unduly humble. I mean, you had indicated that we may not have been the first state to pass the law protecting children, but you with a tremendous amount of foresight anticipated where the the legal and constitutional challenges would come from in other states, anticipated that, remedied that in our proposed passed legislation, and therefore Connecticut is an island that has not been sued. And so that's a tremendous credit to your wisdom in this. And I just want it very clear that I'm hoping that the lion sleeps with the lambs on the artificial intelligence endeavors as well. Maybe not anticipating legal challenges much as gubernatorial veto challenges, but I think those hurdles can be overcome just as anticipating potential lawsuits. And I just wanted to give you props for all the hard work that you've done in this area, and the national recognition you've had certainly is not lost on this senator. Thank you, sir.
Thank you, Senator Kissel. Rep. Ackert.
Well, thank you for the run through on it, because I knew 4 and 5 were added. Sections 4 and 5 were added, new language and comprehensive language. Question is on throughout the legislation, you remove willfully disregards, which I kind of understand that term, and add in knowledge fairly implied based on objective circumstances. What is the rationale behind that? Because I understand willfully disregards. I struggle with this language here.
Yeah, thank you for the question. It's so the initial, I guess, concern was the bar was a little too high from the AG, who's charged with enforcing, and we're going to go in the data privacy next, and we'll talk about why we made some of those changes. The willfully disregards would mean we don't want to incentivize people to turn a blind eye, right, to the age.
Okay.
And so we want it to be more than just the actual knowledge. And a lot of the reason why the children's bills have been found unconstitutional, and I'm not a lawyer, but I've just read the opinions, is when they require age verification, right? They tend to say that limits the free speech of people who are of age and unnecessarily limits their free speech. They usually cite this case from the Supreme Court, Reno versus ACLU, which was on an age verification case. So that's why we went with the actual knowledge or willfully disregards, which is the basis of most of the privacy law. However, to try to be a little more cautious when it comes to children, right? We added that knowledge let's see, it's fairly implied based on objective circumstances. That came from the federal COSA bill that had passed out of the Senate and didn't make it. And it was actually based on rulemaking regarding the FTC. So once the FTC has put forth rules, if you have, that's the standard they use to know if you should have followed them, actual knowledge. And so there is court basis for that. So there is basis for that standard. So it kind of strikes the balance between not going to age verification. And so an example maybe is that I've talked with developers of some of the social media models where they say over time, by the way you interact with it, by the way you interact with Facebook or Instagram or X, they know your age. They can determine it. And so that would be a knowledge fairly implied based on, objective circumstances. So again, we don't want to limit people ahead of time by requiring age verification, but we wanted to make sure we're protecting kids.
Thank you, Mr. Chairman. I appreciate that. Good.
To me.
Representative Tigliano.
Yes, Mr. Chairman, with the condition that there's a couple of minor remaining issues and that there's still a little bit of work to be done on this bill, with your commitment, we could offer this for the consent calendar.
Great. So motion has been made to move this consent calendar, and you do have my commitment. Are there any objections to adding this to the consent calendar? Okay. Hearing none, so moved. Okay. Next item on the agenda, number 19. Oh, 20. Okay, next is number 20, 1356. Hold for 1 second so I can find my. Okay. So item number 20, 1356. I would entertain a motion to JFS to the floor, LCO 6718. Is there a motion to JFS to the floor?
So moved, Mr. Chair.
Okay, moved by Representative Lamar. Is there a second? Seconded by Representative Luxembourg. Just going through the bill, Section 1 expands the definitions. And actually, let's go a little bit of the genesis of the bill. One, we were the 5th state to pass data privacy. There have been, depending on how you count what's comprehensive data privacy, 15 bills passed since us. And so we have some learnings. Also, the Attorney General issued a report on enforcement in the first 6 months. And a significant amount of the complaints that came in fell under one of the exemptions we had put in this bill. And that's why from the AG, we felt that we needed to make some changes to the bill. One of those was an entity level exemption for GLBA entities, so which are banks, Graham-Leach-Bliley Act, banks and insurance companies. And what had happened in Texas is that auto dealers were claiming that exemption because they had finance units. And so we know that cars are one of the largest collectors of data, and we determine your location data as sensitive data, so we didn't want to allow them to sell that data without you giving them permission. So that's one of the important changes in the bill. We did expand the definition of sensitive data, and I just want to read some of the items that we added in the definition of sensitive data. And so the reason that's important is sensitive data, unless you opt out, you're saying that companies can sell your data. However, for sensitive data, we say you have to give permission to sell or to share that data. And so what we're adding into sensitive data are things that I'm sure many people thought would have been included initially, but let me get there. So in addition to physical health condition or diagnosis, disability or treatment, we do expand the biometric data information, but if the data of a child, we change the knowledge standard, neural data, but also financial information that reveals the consumer's financial account number, financial account login information, or credit card or debit card number, that in combination with any required access or security code, password, or credential will allow access to a consumer's financial account. So these are some of the items, as well as your government-issued identification numbers that have been added in to the bill. Let me go back. In section 2, we reduced the threshold. So initially we were at 100,000. We go down to 35,000 residents. First, I think Montana lowered it after us. Initially in the bill, we were at 60,000 based on the fact that the states that had passed it before us were significantly larger and had 100,000. And so it was a negotiation in the end to go up to 100,000. So we went to 35,000 has been done in Maryland and Delaware. We go to 0 if you're selling people sensitive data. Remove nonprofit from the list of exemptions, as well as the aforementioned GLBA entity and HIPAA entity exemptions. There's a blacklight tool where you can go on websites and see the data trackers to find out how much data they're tracking and selling. And there are some organizations that are nonprofits. If you go on the blacklight tool, they have 13 or 14 data trackers on there. So sometimes, again, we're not saying they can't have their websites. We're saying they have to abide by the bill. Section 4 adds the right. So section 4 is where we establish our consumer rights. The new thing is to see a list of companies to where your data had been sold. Section 5 is a work in progress. Section 5 is the data minimization. That goes to the Maryland standard. I just didn't have time to get JFS on the data minimization. I am working on something there on the data minimization. And just when it goes to testing algorithms for bias, strict data minimization is at odds with that, because you wouldn't need to collect the gender information or race information if you're trying to minimize what you collect. So the EU does have an exemption for that. So I'm looking at other bills for the data minimization. Section 6 is the exemptions. So Representative Ritigliano will remember we negotiated the first bill. We put in an exemption where if you have someone build your website for you and you don't have actual knowledge that they're going to violate the law, then you're not liable. And so that is still in here in lines 477 to 493. Section 7 went in our previous children's bill. We gave parents the right to delete their children's social media accounts. So that right has gone in effect. Again, only state in the country that has that. And so this is just updating that to say that, and it's similar to other ways in data privacy where if you have an account, you can require them to log into their account, but you can't force them to create an account to exercise that right. And, you know, in the bill, again, it is subject to their commercial verification methods. Sections 8 through 10, we update the knowledge standard in the children's bill, actual knowledge or knowledge fairly implied based on objective circumstances. And then sections 11 and 12, we create a data broker registry.
You done? Thank you, Mr. Chairman. Mr. Chairman, there is general support for this bill amongst our side of the aisle. We had a couple of concerns, one of which was the dropping of the counts from 100,000 to 35. We thought the 100,000 protected small businesses from inadvertently getting trapped in to something maybe they're not really being a part of. We thought 100,000 was a fair number. It seems to be working over the past couple of years. But also, one of our bigger concerns is, and we talked about it before, and I would like you to have the opportunity to explain why not, is that our concern was that the government wasn't mandated to follow the same rules as a private business. We wanted that sort of added to the bill, and then you had an explanation. I wanted you to do it publicly why that couldn't be, or is there a section of the bill where you think we could actually get that in and achieve our goal or the goal? Thank you, sir.
Yeah, thank you very much. And we did work together, and I know this has been important to Representative Candelora. So in 2023, in Senate Bill 1103, we put in there that for any vendor that the state hires, they have to agree to abide by our state data privacy laws. The reason why we couldn't just automatically apply these rules to government is because we have open records laws and FOI and information. And so once you create a government record, right, we can't expand the right to delete to everyone because those are now public records that couldn't be deleted. I do share your belief, right, that there should be limitations on how government uses data as well. And I would commit to work with you to see which of the rights we've created we can apply to government and that wouldn't run afoul of our open records laws.
Thank you. And I appreciate that commitment because really what the goal is to just have the government behave as the private sector would be mandated to behave. And also if you could explain the 100,000 to 35 again. And in reality, it's really not that much different. And aren't you capturing enough businesses or enough data managers, for lack of a better word, in the 100,000 as opposed to the 35?
Yeah, and that is a good question. I think that because people have to comply with the 20 different states now, the majority of people, if you're having your website, if you're going to WordPress, if you're hiring a vendor to build your website, they're already built to be compliant. So when we were the 5th state, it was a little different because not many states had to comply yet. And if you remember back then, I think there were 2 major companies that built restaurant websites. It was Pop Menu, and I can't remember the other one. Pop Menu is down in Atlanta. I called them because I looked at a few restaurants that had their website and it said, compliant with the California Privacy CPPA. And I called and I said, well, are you charging extra to make it compliant with Colorado, since Colorado was going into effect? And they said, no, we just build our sites that way. So I think the thought is now that, when things are new, there aren't as many tools to comply. And now that it's been in effect and other states have adapted it, it's easier to comply with the bill because there are more tools. But initially we did want to go to the lower number because, California is 100,000 residents. 100,000 out of California is much lower percentage than 100,000 out of the 3.6 million. And so we had adjusted it. If you went percentage wise, it probably would be in the I think it was like 65,000 there. Representative Yacarino.
Yeah, thank you, Mr. Chair. My concern, I think most of the bills really well drafted. I do have a concern, and maybe you could educate me here. So I have a website for my business. A lot of businesses have it. It's Shopify. I pay them every month. And you either could be active in your website or not. We've been very active over the last few months. So it's our visits and our interaction is growing every night, actually. How will that affect businesses, not just like mine, but any small business? Well, do we have to fill any paperwork or any other requirements? It's a little confusing.
Yeah, so I did go to your website to check. So I was hoping to see it was already compliant. You do have a terms of service, which is the same as we require a privacy notice. And then the other is just the right to opt out of the sale of data. So if you're not opting out, but typically what would happen is it would be your vendor who would provide those tools. And I didn't have the time today to call Shopify and see what it would take for them and if they charged extra, but that is something I would look into. But you're like most small businesses, right? You're going to use Wix, you're going to use WordPress, or you're going to use Shopify or something else to create your website. So I will, commit to checking with them. I know WordPress because I've built my websites on WordPress. You can either get plugins or other tools to make you compliant. But I'll check with Shopify and Wix to see what it would take.
And they charge you, Ben that used to work for me, who was my manager, he built it. And Kevin monitors it. He's a computer data processing graduate student. But it's really a great tool for businesses. You just don't want to start stifling any more business. And most businesses comply with the way they're supposed to anyway. They don't give the information out to anybody, but it's all internal. So that's the only thing I'm concerned about. Not just for me, but any business, actually.
And that's why, like, if you hired, we do have in there the provision where if you hire a vendor, right, and they're building your website, as long as you don't have actual knowledge that they intend to violate the law, then you're not liable. So they don't say, hey, we'll build you a free website and sell all of your customers' data, right? Like, as long as you don't know that, there are protections in there, but I can look and investigate further with Shopify what it would take for them to make it compliant.
I'll check also, but I appreciate your time. Thank you.
Thank you. Data privacy is not the most exciting topic for 3 o'clock on a Friday afternoon.
I don't know. The front row is riveted.
Call me a nerd and you wouldn't be the first.
I got snacks when we went to the movie.
So, and I left my bag of chocolate covered espresso beans in the car. Senator Chicarella.
Thank you. And we've been discussing this bill for a while. Actually, we passed the bill a couple of years ago. And I understand that this is an attempt to try to get some areas that we may have missed, specifically banking information and making sure we're protecting the consumer. And I understand the intent and as Representative Retigliano stated, for the most part, we're behind the concept. The concern is, again, unintended consequences to the businesses. So I just have a couple of quick questions. As we just said about Mr. Yacarino, Representative Yacarino's website, we went and all looked.
Yeah.
Four of us were together. We went and looked and saw. And now that we all look, we probably put him over the
He's 3 hits
threshold. and
closer to the
yeah,
threat.
we're gonna try to get him in trouble here. But I guess the simple question is, he may not be in compliance. We'd have to look a little further. But what would be the penalty to a small business like Representative Yacarino's?
Yeah, and so, actually, you bring up a good point, is that when we started the bill, we initially had a cure period so that you could fix it. Right now, I think we are past the cure period, but we are in a permissive cure. So the AG would have the ability, based on the size of the business, sensitivity of the data, he's not really collecting anything, to say, hey, you need to update your privacy policy. It would be a CUPPA violation, which I believe I need to look at. I think it's, is a CUPPA 2,500 per violation? It would, yeah, so like a privacy policy would be one, but if you sold each person's data, it would be,
each person
right,
would be one.
yeah.
So, and just for the sake of time, I know our good LCO staff is trying to find that, but even if it's 2,500, 5,000, or even 500, it's per person essentially that would be subject to possibly having a data breach, correct?
It would be the sale of someone's data. And again, the way that it is set up for enforcement, you have to specifically opt out. You have to go to the website and say, no, you cannot sell my data. So then if someone said, no, don't sell my data, and you still sold their data, that would be a violation. If you sold their sensitive data, like their credit card information, that they need to give you permission to sell that. So that would automatically be a violation. But if it's just general, where were you looking? What's your ad? That stuff, you can sell it unless they tell you not to. So that's why I think in some ways, for what they call the foot fouls, like if your privacy policy, you didn't list everything, right? We give the AG the ability to just send you a letter, fix this in 30 days, and there's no penalty. And they're not looking for, because it's solely enforced by the AG, they're not really looking for smaller businesses.
Thank you for answering that question. And that's part of my concern, not just one section. And for the sake of time, I'm not going to go to other issues that I have when it comes to business. But again, someone not even knowing they're doing something wrong, they don't get the letter if it comes, and a small business could be really negatively impacted. And that's a concern. But I do know that you are willing to work with us on this. We're going to try to get that number up a little higher, from 35,000 back up to 100,000, somewhere in that middle. But at this point, I'm going to vote no to flag it and hope that we could get it to a point where we could achieve the goal of trying to protect individuals with not having the possibility of hurting our small businesses. So thank you.
Great, thank you. Is there any further discussion? Okay, hearing none. Madam Clerk, will you please call the roll?
Okay, a motion has been made to JFS to the floor, SB 1356, LCO 6718, an act concerning data privacy, online monitoring, social media, and data brokers. Senator Maroney,
Yes.
Representative Lamar, Senator Fanfara, Representative Turco,
Yes.
Senator Ciccarella, Representative Vertigliano, Representative Ackert, Representative Ali Brennan, Representative Aniskovich, Representative Candelaria, Senator Gadkar Wilcox,
Senator Gadkar Wilcox is yes.
Representative Gibson.
Representative Gibson votes yes.
Thank you. Representative Jensen. Senator Kissel. Senator Lopes.
Senator Lopes votes yes.
Representative Luxembourg. Representative Martinez.
Yes.
Representative Osborne. Senator Austin. Representative Paolillo.
Representative Paolillo votes yes.
Representative Santos. Representative Yacarino.
Representative Yacarino's no.
Okay, thank you, Mr. Chair.
Okay, thank you. We're holding the next item, 1357. So item number 22, Senate Bill 1463. I'd entertain a motion to JF that to the floor.
Second.
Item has been moved by Representative Tigliano and seconded by Representative Lamar. So this bill takes deposits from the sales of the online lottery and the lottery's share of sports gaming and deposits that into the Early Childhood Care and Education Fund, increases the commission given to lottery agents from an average, a maximum of 4% to 5.5%. I was interested when they testified their margins, right? I think it's the payout's 67%, so they have a 33%
Yeah.
margin there. Just as an aside, sections 6 to 9 exempt the name of the winners, their photos, and their addresses from being posted on the website, but it also does exempt them from FOI. We have received concerns about that, and I think that is something we are going to work on. We just didn't have time to do the substitute language. We don't think that you should be able to publish the name and address of a lottery winner on the lottery's website without their permission. However, we do need to know real people are winning lottery, and I do agree with some of the people who are opposed to the FOI exemption. So that's something you have my commitment to work on. Representative Lamar.
Thank you. And I just want to reiterate that commentary. We received great feedback from FOI about their concerns with respect to that provision. That isn't the intent. The intent isn't to make it so like these folks, you can't find out who they are, if they're real or not, if they're engaged in some nefarious activity. We instead just didn't want folks to have to have their names and address disclosed for promotional activities or like on the website. The name should be available. They should be FOI-able. Folks should be able to research them. But they don't need to be used for marketing purposes.
Thank you. Representative Tigliano.
Mr. Chairman, I'd like to offer this for the consent calendar.
I'm sorry. I would entertain a motion to JF to the floor, Senate Bill 1464.
So moved. Second.
Moved by Representative Lamar, seconded by Representative Tigliano. Okay. It authorizes the Senate Bill 1464 authorizes the governor to negotiate for the multi-state poker, interstate gaming. It also, thanks to the suggestions of Representative Scott, we have in a section in there on when someone gets limited, sometimes they'll get limited when they're gaming, restricting the games that they can play and they won't know why. We do need to work on that language. I met with Representative Scott and DCP, and there's another section in there he had requested. And they're both really notification sections that he feels that the consumer should be notified about why they were limited and such. So with that, Representative Tigliano.
Mr. Chairman, I'd like to offer this to the consent calendar.
Motion was made to move that to the consent calendar. Is there any objection? Hearing none, so moved. We're holding the next 3 items. So we're moving on to item number 27, House Bill 5269, an act concerning gaming advertisements and permissible payment mechanisms. I'd entertain a motion to JF that to the floor.
Second.
It's been moved and seconded. Representative Tigliano.
I'd like to offer this for the consent calendar.
Great. Motion has been made to move that to the consent calendar. Hearing no objection, the item will be moved to the consent calendar. Next is item number 28, House Bill 5272. I would entertain a motion to JF that to the floor.
So moved. Second.
Okay, motion has been made and seconded. Is there any discussion? Representative Tigliano.
Without objection, Mr. Chairman, I'd like to offer this for the consent calendar.
Is there any objection to moving it? A motion has been made to move that to the consent calendar. Is there any objection? Hearing none, the item is moved to the consent calendar. We are going to hold numbers 29 and 30. And number 31 I would entertain a motion to JF that to the floor. Senate Bill 1465.
So moved.
Item has been moved by Representative Lamar and seconded by Representative Retigliano. Okay. Representative Lamar.
Thank you, Mr. Speaker. Mr. Speaker, there's been a series of conversations that have happened over the last few months, frankly, the last few years, with respect to the ratio relief program. We have been benefited by an incredible amount of work that's been taking place by Senator Ciccarella, the leadership of this committee, working closely and collaboratively with the building trades and the Department of Consumer Protection and the Department of Labor. We think we've clarified a process, will bring clarity and transparency to the process, will provide necessary relief in some circumstances while we're protecting the building trades as a whole. Unlike what you've seen in other committees in the building, we think we've negotiated a good policy that will have bipartisan support in both chambers, support of the building trades, and support of those companies looking to get this type of relief. I frankly am just deeply respectful of the amount of work and time and talent and energy that you specifically, Senator Ciccarella, have put into this. It's taken a lot of work to get to a place where people feel like we have the trust and confidence of folks that we're moving forward. I know there are other bills that might come to us that we might not see so favorably on this issue. But this one, I think you've done incredible work on, and I'm excited to work with you moving forward.
And I just want to echo Representative Lamar's statements. I think this is an issue that's been before our committee for probably every year that I've been on the committee, so for the last 5 years. And I want to applaud Senator Ciccarella for his work to come up with a solution, to work with Commissioner Caffarelli, to work with the unions and Representative Lamar as well to come up with the solution. So I just want to applaud that good work that you've put in. And before I recognize you to speak, Representative Ackert.
Thank you, Mr. Chair. So I was so hoping to see that JFS language as one of the, I think, 27 bills that had an S language on here. So I look forward to that language. At this time, I'll support this legislation moving forward. And I think that the effort that has been put in on behalf of the future trade workers for the state of Connecticut. Thank you.
Thank you. Senator Ciccarella, you're okay? Okay. Representative Retigliano.
Mr. Chairman, I'd like to move this to the consent calendar.
Okay, a motion is made to move the item to the consent calendar. Is there any objection? Hearing no objection, the item will be moved to the consent calendar. Madam Clerk, will you please call the consent calendar? She has to read every bill. This is not the end of the day for, we will be going back to Senate Bill 797 after the consent calendar. Yeah. All right, Madam Clerk, you ready to call the consent calendar?
I'm not sure how.
Okay.
Raise an objection. I don't see Representative Osborne with one.
All right.
Turco's chewing. I just happen to be walking by, you know?
All right. Meeting will come. Now that everyone has a sugar high, the meeting will come back to order. All right,
Whoa.
Madam Clerk, will you
Okay.
please call the consent calendar?
Okay, there is a motion before us to approve a consent calendar which contains the following items. Item 1, JF to the floor, HB 5111, an act concerning mobile home manufactured homes and an act concerning mobile manufactured homes and mobile manufactured home parks. Item 6, HB 6930, JF to the floor, an act concerning the Social Equity Council's recommendations regarding social equity plans, strategic planning, ethics, license renewal fees, and financial assistance applications. Item 8, HB 7179, JF to the floor, an act establishing a task force to study the operations of the Department of Consumer Protection. Item number 10, HB 7182, an act concerning entertainment event tickets, JFS to the floor, LCO 6651 as amended. Item 18, SB 1295, JFS to the floor, LCO 6091, an act concerning social media platforms and online services, products, and features. Item 22, JF to the floor, SB 1463, an act concerning disclosures, payments, and revenue transfers by the Connecticut Lottery Corporation. Item 23, JF to the floor, SB 1464, an act concerning sports wagering and multi-jurisdictional internet gaming. Item 27, JF to the floor, HB 5269, an act concerning gaming advertisements and permissible payment mechanisms for online gaming accounts. JF to the floor. Item 28, JF to the floor, HB 5272, an act prohibiting certain gaming-related advertising, marketing, and promotional activities. And item 31, JF to the floor, SB 1465, an act authorizing the Commissioner of Consumer Protection to allow certain skilled trade licensees to deviate from certain skilled trade hiring ratios. Well, I think I did in 1294. And just in case we missed that, item 18 is also on the consent calendar. That is SB 1295, JFS to the floor, LCO 6091, an act concerning social media platforms and online services, products, and features. Okay, I will now call the roll. Senator Barone.
Yes.
Representative Lamar. Senator Fanfara, Representative Turco.
Yes.
Senator Ciccarella. Representative Vertigliano. Representative Ackert. Representative Ali Brennan. Representative Yanukovych. Representative Candelaria. Senator Gadkar Wilcox.
Senator Gadkar Wilcox is yes.
Representative Gibson.
Representative Gibson votes yes.
Representative Jensen.
Jensen is yes.
Senator Kissel. Senator Lopes. Representative Luxembourg. Representative Martinez.
Yes.
Representative Osborne.
Yes.
Senator Austin. Representative Paolillo.
Representative Paolillo votes yes.
Representative Santos. Representative Yacarino.
Representative Yacarino votes yes.
Okay, thank you, Mr. Chair.
Okay, thank you very much. Now we're going to return to item number 14, Senate Bill 797. I would entertain a motion to JFS to the floor, LCO 6100. Representative Lamar.
Mr. Chair, now that everyone's received some snacks, I would like to move this item.
A motion has been made. Is there a second? There is no popcorn. Instead, we had cannolis. So, motion has been made. Representative Paolillo, would you like to second the motion? Motion has been seconded. Thank you to the New Haven delegation. So a motion has been made and seconded. Discussion. So this bill comes to us from Senator Looney. There is substitute language based on input we had received. So instead of requiring the actual start times, because we've heard that they do vary, what this does is when advertising the start times for movies, you must say the actual movie start time may be 10 or more minutes after the movie start time set forth in this advertisement. We did lower the fine. So the initial fine, I believe, was $1,000. It's a $500 fine. With that, Senator Kissel.
Thank you very much, Chairman Maroney. Well, I actually had a little rant when this came up for its public hearing. I don't recall anybody coming to testify that day in favor of this bill. Not for nothing, but I actually sort of believe that if this wasn't the Senate Pro Tem's proposal, that it probably wouldn't have seen the light of day. I don't think if I had proposed this bill, it would have gone anywhere. I have never had anybody in my district complain about the start time of a movie. And when I have gone out in the last few weeks talking about this proposal, people uniformly like the previews. They like to sit there and see if, they're going to like the films or they're coming down the road or, I go with my son who's 21 and we will comment on the coming attractions. Yeah, that looks great. That looks terrible. I can't believe they made that movie. You pick and choose. It also gives you leeway, right? If you make a wrong turn going to the theater or something like that, you got a little buffer zone before the regular movie starts. Sometimes when they have the special reprises, if it's the 25th anniversary of a movie or 50th anniversary of a movie, there are no previews. There is no wiggle room. If you get there 1 minute late, you've missed the first minute of a movie. And I find that more constraining. I also will talk, people may be aware that up in my neck of the woods in North Central Connecticut, we have this failing mall, and we were lucky a couple of weeks ago to have a SIF grant by legislative leadership awarding Enfield and its environs of $10 million to partner with the town of Enfield and these developers from out in the Midwest to turn that mall around. That's going to help us leverage like $200 million in private funding. In the last few years, because of the sinking mall and the fact that the person that bought the mall is just sitting on it to make money and not doing anything to keep it even fire code compliant unless forced, we lost our theater. So in my district, my 8 towns in North Central Connecticut, you have to go to West Springfield or Manchester to see a movie in a theater. I don't feel like we've marched forward in this last decade when it comes to entertainment. We've gone backwards. And here we are penalizing the few theaters that are still around in Connecticut. I thought I saw somewhere, and I don't want to speak out of turn because I really like serving with Senator Looney. We both started in the Senate at about the same time. He was 6 weeks ahead of me because I had a special election. And he served many, many years in the House before I ever got elected for my first term. But I thought I read that he said he prefers Netflix and things that are, on demand on his television set. So I don't see this anything more than a poster child for a very silly bill. And unfortunately, I think it undermines what we do here in this building. There were a lot of really good bills that we had before us this afternoon. They may not be perfect, but, I just think about what Senator Maroney or Representative Lamar do to try to make a good proposal even better. And they spend, and the ranking members, everybody in this building, every representative or senator puts an enormous amount of time in trying to make this state better for our constituents. And how lucky are we that they have voted to have us be their spirit, their mouthpiece, their eyes and ears on what's going on in government. And we're wasting our time on penalizing a cinema $500 because they didn't say when the movie's going to start? I don't get it. And, I am happy person by nature. I'm a hopeless optimist. The glass is always half full. And I know people want to get to soccer games and do other things. So I'm not going to go any further than I am now. I just, would we penalize Shakespeare because he gave us a little Macbeth before he started in on Hamlet? How sad is that? Why are we attacking the entertainment industry? Why are we attacking the arts? Would we even entertain this for the Goodspeed Opera House or the Bushnell Theater? I don't think so. So without belaboring it, and I want to thank Chairman Lamar for these delicious treats, probably from the city of New Haven would be my guess. But with the utmost respect to the leadership of this committee, I just have to say this is not our greatest moment, and I will be voting no. Thank you.
Thank you, Senator Kissel. Are there any further comments? And I think this issue is a good example of how we cover everything in this committee. We've gone from AI to what did we have today? AI, children's privacy, alcohol, mobile homes, ratios, apprenticeship ratios, and now movie start time. So thank you, everyone, for sitting in. Is there any further discussion? Okay, hearing none. Madam Clerk, will you please call the roll?
Okay, a motion has been made to JFS to the floor, SB 797, LCO 6100, an act requiring scheduled start time disclosures and motion picture advertisements. Senator Maroney,
Yes.
Representative Lamar, Senator Fanfara, Representative Turco,
Yes.
Senator Ciccarella,
No.
Representative Vertigliano, Representative Ackert, Representative Ali Brennan, Representative Yanukovych, Representative Candelaria, Senator Gadkar Wilcox,
Senator Gadkar Wilcox is yes.
Representative Gibson,
Representative Gibson votes yes.
Representative Jensen.
No.
One more time so we can get you on camera, Representative Jensen.
Hey, Jensen's no.
Thank you. Senator Kissel, Senator Lopes, Representative Luxembourg, Representative Martinez.
Yes.
Representative Osborne,
Yes.
Senator Austin, Representative Paolillo,
Representative Paolillo votes yes.
Representative Santos, and Representative Yacarino.
Representative Yacarino votes no.
Okay, thank you, Mr. Chair.
Okay, thank you very much. That completes our agenda for today. We will be back on Monday morning at
10 a.m.
10 a.m. on Monday morning. So you can spend all weekend hoping that someone from the beef tip city of Trumbull brings us all beef tips.
And anyone who's had business before the General Law Committee, please come by, grab a cookie, grab a cannoli, and we'll see you Monday morning.
So we are in recess until 5 p.m., at which time we are adjourned. Thank you.
Hello, Madam Clerk, are you there? No? Madam Clerk, are you still there?
I am here. I'm having a little
Oh.
technical problem.
Good. Can
Yeah,
I?
having little technical issues in the room here. Let me see if I can get the video back on here.
Okay.
I didn't say it already, but we are.
There we go. All right, let me see. We could go back through here. Make sure we got you on everything here. All right, the first thing we had that you missed was JF to the floor, HB 5428, and act concerning mobile manufactured home parks.
I'll vote no.
Okay, thank you. Then item 3, JF to the floor, HB 6052, and act concerning the Home Solicitation Sales Act and residential solar photovoltaic systems, JF to the floor.
Yes, that's a no.
Okay, thank you. Then we had a voice vote that was just a technical amendment to
Oh,
7180.
yeah. Yeah, that's good.
Yep.
Yep.
And next was SB2 JFS to the floor and act concerning artificial intelligence.
Yeah, that's a no.
That's a no. Okay. And let's see. Next was SB3 JFS to the floor and act concerning consumer protection and safety.
Oh, man, I guess no.
Okay.
It's a tough
You have
one.
till 5 o'clock. Next was JFS to the floor, SB 514, and act establishing a net equality program. We got you on that already.
Yep.
We got you on 1249. Let's see, the next one that we don't have you for is SB 1356, and act concerning data privacy, online monitoring, social media, and data brokers, JFS to the floor.
I'll go vote no on that.
Okay. And let's see, we got your vote on the consent calendar.
Yep.
And we got your vote on 797. Have a good weekend.
All right, thanks. Yeah, I had some technical issues with some of those first ones. Yeah. Okay.
All right.
Very good. Thank you.
I'm sorry, I'm having the room's super loud here right now.
Yeah, it's loud here too. Okay, thank you.
Have a good weekend. All
Bye
right,
now.
let's see who's next here. All right, let's see. Representative Representative Candelari's got his hand up here. Can I see? There you are. You're on camera. Okay. So, whoops. Oh, I see Representative Gibson now instead of Representative Candelaria. That's interesting. Oh, you are still there, Representative Candelaria. Let's see. Okay. First we had HB 5428, JF to the floor, and act concerning mobile manufactured home parks.
That's a yes.
Okay. And then 6052, JF to the floor, and act concerning the Home Solicitation Sales Act and residential solar photovoltaic systems.
That's also yes.
Okay. And then we just had a voice vote on a technical conforming changes to 7182. Next was SB2, an act concerning artificial intelligence, JFS to the floor.
That's a yes.
Okay, then SB3, JFS to the floor, and act concerning consumer protection and safety.
That's a yes.
Okay, next we had JFS to the floor, SB 514, an act establishing a net equality program.
That's a yes.
Okay, then we had JF to the floor, SB 1249, an act addressing innovations in artificial intelligence.
Yes.
Okay, and then we had 1356, JFS to the floor, an act concerning data privacy, online monitoring, social media, and data brokers.
That's a yes.
Okay, and then we had the consent calendar.
Send this again.
That's a yes, okay. And then finally, last one was SB 797, JFS to the floor, an act requiring scheduled start time disclosures and motion picture ads.
Yes.
Okay, all right. Thank you. That's all
Thank
the
you.
weekend.
You too. Take care.
Thanks. All right, let's see. I'm gonna admit somebody else who was looking here too. All right, Representative Gibson, let's see. I have you for 5428. I have Representative Gibson, I have you for 6052. I have you on SB2. I have you on SB3. I have you on 514. I have you on 1249. I have you on 1356. I have you on the consent calendar. And I have you on 797. So you're all set.
All right, great news. Thank you.
All right, great. Thanks. Have a good weekend. All
You too.
right.
Enjoy your weekend.
Thanks, Senator Gadkar Wilcox. All right, let's see. Okay, first up, we need your vote for 5428 JF to the floor and act concerning mobile manufactured home parks.
Yes.
Okay, thank you. And then 6052 JF to the floor and act concerning the Home Solicitation Sales Act and residential solar photovoltaic systems.
Yes.
Okay. And then that was just a technical and conforming changes to 7182 was just a voice vote. Next was SB2 JFS to the floor and act concerning artificial intelligence.
Yes.
Okay. And then SB3 JFS to the floor and act concerning consumer protection and safety.
Yes.
Okay. And then thanks. JFS to the floor, SB 514, an act establishing a net equality program.
Yes.
Okay, then JF to the floor, SB 1249, an act addressing innovations in artificial intelligence. We got you there as a yes.
Yes.
Then we got your vote on 1356. We got your vote on the consent calendar and we got your vote on 797.
Great. Thank you so much.
Have a good
Thank
weekend.
you too.
Thanks. All right, Representative Santos, let's see what we're missing here. There were a couple. Got you for 5428. Got you for 6052. Next was a voice vote that was just technical changes.
Yep.
Got you for SB2. You're there. Oh, SB3 JFS to the floor and act concerning consumer protection and safety.
Yes.
Okay, thank you.
I was there for SB2.
Yeah, I had you
Okay.
for, yep, I had you there for SB2.
Somehow I don't remember that. Thank you.
Okay, thanks. Let's see. 514 JFS to the floor and act establishing a net equality program.
Yes.
Thanks. Then 1249 JF to the floor and act addressing innovations in artificial intelligence.
Yes.
Okay, and then JFS to the floor, 1356, an act concerning data privacy, online monitoring, social media, and data brokers.
Yes.
Sorry.
And finally, the consent calendar.
Yes.
Okay.
I understand.
All
Thank you
right.
very much, Betsy. Have a good weekend.
Thank you. You too.
Bye-bye.
Bye-bye. Wait. Hey,
Hello, Jen.
Representative. Sorry that that last sheet stuck there. I got to take
No
your
worries.
on 797 JFS to the floor and act requiring scheduled start time disclosures and motion picture ads.
Yes.
Okay. All right. Thank you very much. Have a good
Thank you.
weekend.
You too now. Bye-bye.
Bye-bye.
Right, I'm gonna go up to.
Up to 30, yeah, just in case anybody is up there looking to vote.
That's good.
Thank you. Thank you.
We have a feast on the way home.
Yeah. I've worked so hard to drop so much weight over the last year. I can't even look at these in the car.
Oh my God.
Well, you can
smell them, so I think you're
Yeah.
Yes,
I'll make it to my kids' games and make me the happiest dad on earth.
that's perfect. It's good.
All right, is he popping on here or not? Let's.
Hey, Betsy.
Oh, I'm sorry. Oh, I'm sorry. I realized that the audio was off there. I was halfway through all these tally sheets here.
Oh yeah, no worries.
Anyway, I'm sorry. I'm just checking through here. I got your vote on 5428, got your vote on 6052. 7182 was just technical and conforming changes, a voice vote. Got your vote on SB2, got your vote on SB3, got your vote on 514. 1249, JF to the floor and act addressing innovations in artificial intelligence.
Yes.
Okay, thank you. And then 1356, JFS to the floor, an act concerning data privacy, online monitoring, social media, and data brokers.
Yes.
Thanks. And then the consent calendar.
Yes.
Okay, thank you. And then last but not least, 797, an act requiring scheduled start time disclosures in OSHA
yeah.
nature ads. Yes.
Yes, for Senator Looney, yes.
Okay. All right. That's them all.
All right, thank you so much. Happy Friday. Enjoy your weekend.
Happy Friday. Bye-bye.